Okay, I think it's just gone past, so we'll make a start on this final session of this two-day conference. I claim no credit whatsoever for the title of this panel, but I do think it is an excellent one, and it's on armed conflict and the challenges to international peace and security in a multipolar world. And just by way of very, very brief introductory remarks, I think we can all agree that that the world is more unpredictable, volatile, and dangerous now than at any time since the end of the Cold War. And wherever we look in the world, we see that, and we'll touch upon some of the conflicts over the next hour or so with the panelists. But I think it's also fair to say that the rate of technological change is also as rapid now as it has been in many, many years, whether it be in the world of artificial intelligence, lethal autonomous weapon systems, hypersonic missiles, the list goes on and on. And I think the beauty of this panel is that the experts we have before us will touch on each of these areas, and hopefully in the questions we can perhaps draw some of that together at the end. What we will do is this. Each panelist will speak for 15 minutes in consecutive order, and then we'll take all of the questions at the end in the last 15 minutes. And hopefully that will be an efficient use of your time, the panelists' time, and my time. So without any further ado, I will invite the first panelist, Liuva, to come and present on her aforementioned topic. Thank you.
Good afternoon, everyone. Given this is one of the concluding panels, I'd like to take this opportunity to express my gratitude. I would like to thank all participants, panelists, and moderators for joining this year's annual conference, especially organizers and coordinators, and the whole team of the CILJ. In appreciation of the moderator's presentation, I will introduce my master dissertation, Hide and Seek with Private Military Companies, PMCs. The urgent need for international regulatory framework. Prior to delving into the core presentation, allow me please to share a brief disclaimer. I wish to clarify that this presentation is neither affiliated with the Intergovernmental Working Group or IJWG, which I collaborate with, nor it does originate from the United Nations. To be explicit, I'm presenting my independent research, which initially began as my master thesis, and I hope it forms the foundation for a prospect PhD, my work in the future. Consequently, this is not a report presented on behalf of the United Nations. Nonetheless, it's pertinent to mention that I contribute pro bono work to the Office of the High Commissioner of Human Rights Secretariat, having made this clarification, ensuring our alignment. I'll therefore proceed with the presentation per se. So considering the time restraints, this is just like a quick overview on how the presentation is gonna be. Oh God, okay, well, I'm sorry, I don't know what happened. Technical issues, it shouldn't be like that. But just moving forward directly to the introduction, I would like to start quoting Kevin O'Brien, who said that one of the most common fallacies in discussing the existence of PMSCs is that they are a new phenomenon. In fact, nothing could be farther from the truth. Indeed, the origin should be placed in British 1960s, when Colonel Sir David Stirling gathered former British Special Air Services, CAS, and founded OHCHR International. However, the turning point in legitimacy and international recognition of PMCs started with the DSL, the Defense System Limited, which actually cast off traces of mercenarism, aiming to boost its reputation and therefore being able to legally contract former military personnel to meddle in territories of conflict. This project initiative, however you would like to call it, actually, it successfully ended up since it got hired by NGOs, UN itself, the World Bank, among others, between the 80s and the 90s. Therefore, we could say that the promotion of PMCs started from mid-70s, post-Cold War till the present days, and it was fostered not only by states, but also from agencies within the international community, and therefore those should be investigated as well, along with the states and enterprises subcontracting PMCs. I know there might be some new concepts. I will keep explaining them during the presentation. So I would like also to quote again O'Brien and Leander especially to bring some clarification into the presentation. PMCs are considered to be the cover wing of government policies, interpreting homeland intelligence almost on behalf of public authorities, also known as governments. Therefore, their cost benefit is extremely lucrative since they don't have to actually pay extra attention to healthcare or pensions, for instance. Indeed, quoting Perlo, Freeman, and Scones, the attractiveness of PMCs is this ambiguity in terms of they are acting as soldiers while they are not part of the army. In case you are not so familiar with Blackwater PMCs in general, let me quote Al-Marasi, who actually mentioned that Blackwater paved the way for the Wagner Group, which might be a bit more well-known considering the current times. But in a nutshell, Blackwater is a North American PMC founded in 1996 by Erin Print, a former Navy SEAL, as a result of military budget reductions by the United States Department of Defense, causing an enlargement in subcontracting those private enterprises, which not only perform military services, but also provide humanitarian aid, which I will delve deeply later on. Moving into the next section, which I titled problem, but mainly is the research question presentation, which must be the essential elements and principal aspects of an international regulatory framework on PMCs and their activities. So now that we know the case of a study and what PMCs are, what should we do with legal document we should be creating to actually start regulating, since there are no current regulations? We have to take into account that there is one main problem that is the struggle in tracking those PMCs, along with those who, the agent that in case is the UN that is leading this control and tracking was a former employee. So in order to actually answer this question, I propose a correlation between the concept international security, which is the dependent variable, and the juxtaposition between accountability and privatization with my work as the independent variable, considering that PMCs do affect international security, are agents in international security, especially through being subcontracted by state and subcontracting other enterprises. If you allow me, I will skip this. Hopefully, if the article gets published, you could go through literature review, methodologies, but I just want to focus on the core of the research, actually. So which are the results? The results are vertebrated by the subsections, which, subsections, by the sub-questions, starting with the first one, that is how states use PMCs as state tool to reach military goals and achievable by governments per se. You will see that in the results I explain a bit more. As so far you've seen during this presentation, I haven't quoted that much the draft report instrument, not only because it's ongoing, but every year keeps changing, new delegations come into sessions, and then what it was agreed maybe 5 years ago is going to be changed in 2 years. Nonetheless, please allow me to quote and make reference to these two concepts, which is state functions and home state, which will actually clarify the answer to the first sub-question. In the first place, we find in Article 1F, state's function, which it was the only subparagraph who actually mentioned the monopoly use of force, which, as you might all know, it is entitled to state that should not be outsourced. In the current fourth draft instrument, this has been modified. And now in Article 1F, we find prohibited activities, which is still being drafted. So it's a list of activities that PMCs cannot do, but also it interconnects with the activities that the states or services the states cannot outsource to PMCs, which in my opinion should be known, but moving on. Then the other concept I would like to put the accent on is home state, which is present in Article 1B. Sorry, I'm mentioning the articles in case you later want to read the instrument, right? So it's kind of a guidance. So in Article 1B, home state, shortly defined, is the state of nationality of PMCs. So in order to clarify what actually is, I will make use of my case of study, which is Blackwater. Blackwater's home state is the United States of America, because it was the country where it was founded, where it's established, and the CEO comes from. this is quite important as well, because I would like to quote the Congressional Budget Office report that it was published in 2008, and it's titled Contractors' Support of U.S. Operations, in which it explicitly quotes Blackwater and explains differentiation and the reasons why, justifying the US used PMCs. Considering that in peacetime, the costs of the US Army operation in comparison to Blackwater are extremely different, starting by the fact that in the aftermath of the Iraq conflict, Blackwater did not have to renew the contracts, while the army remained in force even in peacetime. Therefore, it's not only the expenses they have in wartime, but also the ones while there is peacetime. So to give you sort of numbers, so maybe it will give you a bigger picture. The CBO estimate that the Army's annual peacetime costs 60 million to maintain 2.2 units, where one unit again represents about 1/3 of an Army light infantry battalion. So lots of money, to present it a bit more easy. So not only states use PMCs due to financial instabilities, economic needs, but also in humanitarian matters, which I would put more accent in here, especially because it's a clear example of human rights abuses. So let me quote the analysis and research team of the European Council, which established that privatizing national forces became a key tool for the US strategy in the war against terrorism. Again, CILJ also suggested that supraterritoriality is far from the extinction of armed conflict, but the scenario for racism, ultranationalism manifestations, terrorism, and religious fundamentalism materialized in the 9/11 mainly. Therefore, PMCs are part of the process of privatizing security. But I would say that not only that, but it might be presented as one of the core roots of this privatization. At the same time, according to the Stockholm International Peace Research Institute, and again, the analysis research team of the European Council, Blackwater has been presented as a category of PMC itself. Moving into the second sub-question, which is how the control and track of PMC's activities recorded and judged under international law, scoping from international humanitarian law, human rights law, and criminal law. It's really important that, considering this international law and the corresponding branches, it kind of overlaps with domestic law and customary law, mainly because the UN is composed by states, member states, and they hold the monopoly on legitimate use of force with the current understanding of the wall by modern states and post-structuralism. So the conclusions that they were extracted from this sub-question is that, first of all, there is no existent regulatory framework on PMCs. There exist some documents, like the Montreal document, that I will explain and specify later on. But there is nothing tangible when trying to control, track, oversee, and actually promote some punishments or consequences towards the actions made. Not only that, but with the legal instrument that the United Nations are trying to build, which it might be this legal document that is missing, there is a huge lack of references to criminal law. Sorry, I will try to speed up now. Of criminal law that it's been advocating for several sessions by different civil societies, but I would not only suggest references in more like a normative tool, but rather with a clear effect and a real effect into what's happening in the world. And therefore, I was going to quote Cassese, but you will read in the article. Then, sorry that I'm going to be quite quickly now. The last sub-question, which are the reasons of legal relevance in international law regarding military-based companies splitting, subcontracting, changing their names, their shapes, their core services. So one private military company has abused human rights, so their way to comply with international human law, but avoiding this punishment or measures that international law might try to apply on them, what they do is they change their name, they collaborate with other companies, they make agreements, as the case Blackwater. First it was Blackwater, then it moved to become Academy, and it was more focused on training, and later on the stage. Now they have a big collaboration with several PMCs and PMSCs as well, under the name of Concelis Holdings. So as a closure, I will just go quickly through the conclusion and recommendations. There is a huge debate on whether private military and security companies should be split between PMSCs or PMCs, depending if it's military or security services. My suggestion is to keep this joint definition and then just specify down below military services, security services, and how both merge. At the same time, I would suggest retaining the inclusion of the principle of the state monopoly and the use of force, as well as strong references to international criminal law, which are really lacking in the instrument currently. Obviously, the main objective of this instrument is to be finalized, but not only that, it's really important to include the contributions from scholars and legal experts. So external opinions from international organizations that sometimes it keeps oscillating between the same opinions. There is an elephant in the room. I haven't approached that much. So briefly, it's the nature of the instrument. So every time it pops up in the conversation, delegations kind of backwards. So my suggestion would be to follow the same path that the Working Group of Business and Human Rights has done, which is first providing some guiding principles, non-binding, and then start with a binding instrument. And that's the end. Thank you so much. And if you want, sorry that it was so tight. I'm really passionate, about this topic, as you can see. It's my master, so it's kind of my baby. I'm still working on it. But if you want to scan it, you can go through it, and I'm open for questions. And I'm so sorry that I'm over time. I'm sorry if I speak so quickly as well. Okay, sorry.
Thank you very much for having me, dear colleagues. The title of my presentation is I don't have slides because I'm always afraid of my letters getting mixed up. The title of my presentation is The Law of Multipolarity, How Russia Creates Its Alternative Legality. So what I would like to present are some reflections on how the Russian invasion of Ukraine contributes to the sense of anxiety about international law, reflected also in the topic of this conference, and challenges some core ideas about what it means to speak the language of international law. It is no big discovery that the invasion reflects Russia's discontent about the international legal order, which was established in a way of sort of silent revolution at the end of the Cold War, as Professor Angi mentioned today as well. And an important aspect of that discontent has to do with the rejection of international legal liberalism, but not only as related to certain substantive issues like democracy or human rights, but also as sustaining the structure of the international legal argument. And I believe that one of the constitutive parts of Russia's image of the multipolar world, one of its beloved concepts, is the rejection of the monophony and unity of the grammar of the language of international law. So for this reason, I'm interested not so much in what Russia has done with the invasion of Ukraine, but in what it has said about the legality of its own actions and on which basis that legality has been ascertained. So as you know, the invasion was accompanied by President Putin's address, in which he laid down the reasons and justifications for the use of force. They were met, and rightly so, with an overwhelming rejection by the Western states and by international legal academia. So these justifications were brushed off as nonsensical, outlandish, and bizarre, lacking substance both in fact and in law, and ultimately failing to provide even distantly plausible interpretation of the jus ad bellum. So according to many commentators, there was hardly any law in it. And indeed, the address mentioned specific rules of international law only twice. It was Article 1 and Article 51 of the UN Charter. But even those had very little connection to the rest of the address. We would find there many more claims about international law rather than on the basis of international law. It speaks about international law as having been butchered by the West, more specifically by the US, how it has been unilaterally rewritten only to become systematically ignored, and so on and so on. The collapse of the Soviet Union, in Putin's reading, signified a new era in which, in the eyes of the West, all treaties became de facto void. But the address speaks very little indeed about the justification for the use of force against Ukraine as grounded in legal rules. It is not even Ukraine against whom the self-defense is being invoked here, it seems. Ukraine and Ukrainians have literally done nothing in this speech. They are only mentioned in the passive voice. So now that's what sustains these claims as legal then, in Russia's view. And by asking this question, I am not trying to say that Russia's justifications of its invasion of Ukraine and subsequent annexation of Ukraine's sovereign territories as legal have, contrary to the accepted view, any validity under rules of international law. Rather, I hypothesize that Russia's insistence on legality of its action does not have much to do with rules or the legalistic ethics to begin with. And by trying to read them in this light, we might actually be missing a point. I suggest that what Russia counts here as legal is assumed within a different frame of reference. And this is what I call alternative legality, kind of a separate set of criteria for what counts as legal or illegal. So let me return to the Putin's address for a second. After all, it is a speech by a politician, so perhaps it wasn't supposed to be about international law at all. Well, Russia presented it as offering its account of precisely the legality of its actions, not once, but twice. First, it was submitted to the United Nations Security Council as Russia's official Article 51 letter. And then the second time, it was submitted to the International Court of Justice in response to Ukraine's request for the indication of provisional measures under the Genocide Convention. And in this second instance, it was also accompanied by a brief annex, essentially saying that, look, the Genocide Convention has nothing to do with it. It's all about self-defense. Here, read the letter, it explains it all. So taken at the face value, from the Russian point of view, this letter is definitely about international law. They present it twice as outlining legal justifications for the invasion. But what is more, we see almost the same arguments and claims about the legality of Russia's use of force, and this time also the annexation of Ukraine regions, in the judgments of the Russian Constitutional Court from October 2022. Once again, it is remarkably thin in terms of engagements with specific rules of international law. There are only general references to self-determination and self-defense. Moreover, we will not find in the judgments much of what would conventionally count as legal interpretation. So the court, for instance, never explains how exactly the principle of self-determination applies here. It simply says that it does, or what it sees as its normative content or conditions of realization. Neither does the court discuss any criteria or conditions for the use of force. And in a rather curious way, it sets aside the question of Ukraine's territorial integrity as irrelevant to the question of annexation of Ukraine's territories. So the court concludes that the use of force and annexation were not just in conformity with international law. It actually says that Russia was under legal obligation to invade and annex Ukraine's territories. But what are the grounds for this conclusion? In virtue of what is this legal exactly? It is not rules, apparently. What is it then? So a closer look at both the letter and the judgments of the court would reveal that the main justificatory work here is carried out primarily by historical narration. So because international law has been ruined by an adversary, the US, international legality is here being reconstructed from scratch, as it were. But this time, not through the rule-centric legalist ideology, but through the idea of international law as this loosely linked set of narratives. So the court, for instance, concludes that Russia's actions present, and I quote, a necessary and singularly available legal means to put an end to anti-legal actions of alien forces, end of quote, because the territory of Ukraine was created by Soviet authorities in an arbitrary way. Ukraine has adopted, under direct involvement of the West, the ideology and practice of aggressive nationalism and anti-Russian neo-Nazism. Russia cannot ignore the suffering of the population that is historically Russian, and inaction in this situation would mean a purely formalistic interpretation of the rule of law, insensitive to deep historical ties with annexed lands. What does it have to do with law? Well, quite a lot, if we take into account some contemporary trends in the Russian legal philosophy, which has traditionally been quite anti-legalistic in a sense that it sees rules only as a superficial layer of the actual normative reality of the law. So to offer you an example, in July 2022, the president of the Russian Constitutional Court, Valery Zorkin, who is also quite an influential legal philosopher, delivered a keynote speech at the St. Petersburg Legal Forum. In it, Zorkin discussed the infamous promise not to extend NATO 1 inch eastward, which was ostensibly made to Gorbachev, which he later denied. So for Zorkin, it does not actually matter whether this promise was made or what sort of a normative commitment it entailed. He claims that the West's insistence that any such promise would require formal consent demonstrates that the Western leaders are driven by a primitive legalistic approach to understanding the law, which ignores the distinction between true law and positive law as fixed in treaty or legislation. So the Russian adjective there is actually quite tricky. It's hard to translate. Something between true, actual, or authentic, in Russian, подлинное. What is this true, authentic law? Well, Zorkin explains that the essence of true law is the equality and freedom, and the necessary implication of it is the principle of equal security. And because Russia was strict, since NATO did not act according to this essence of true law, which it did not know probably about, Russia has the right to protect its security with all means available. And Zorkin further unpacked this idea of true law as rejecting the concept of legalistic, rule-centric image of what it should be. And he says that while the legalistic concept of law stems from a particular set of questions about human societies and liberal political philosophy aim to answer. So he endorses instead, on the one hand, Schmitt's view that any claim of universality is the device of interventionism, and on the other hand, on the Russian jurisprudential canon of the late 19th century, which saw law as implicit in history, not unlike in the German historical school. So in the Russian tradition, however, this is also mixed with certain Orthodox Christian ideas of salvation. And according to Zorkin, this is already from his academic writings, something deep inside our historical personality opposes a definitive division of everything into ethics, aesthetics, and epistemology. There is something definitive or inherent that combines them into one entity. And apparently, he continues, holism professed in Russia meets the current demand. And it is also this holism that makes law and its normative pool bound to Russia's history. So the Russian path to legal freedom, he says, lies in appreciating the living soul of our people, our own historical fate, and our understanding of goodness, truth, and justice. So what to take from it? So on the one hand, I believe we're dealing here with what Timothy Snyder called the politics of eternity, which assumes a view of history as consuming the substance of the past, leaving only boundless innocence of the present that justifies everything. On the other hand, history here does not stay outside of law. It actually informs the structure of the legal arguments. So Ukraine was once legally part of Russia, so it is always legally part of Russia. Yeah, you can't invade the territory that is yours to begin with. Russia once was in a legal right to defend against Nazis. So is it always? It is a historically continuous act of self-defense, and so on. So Russia sees international law as this well of instantly relivable moments where no historical page is ever turned and past is never truly past. So such structuring of the alternative legality allows shifting this central justificatory thrust from rules to what normally does not register as having much to do with positive law and rights and obligations grounded in rules. But since the whole rule-centric rationality with its insistence on the rule of law is only representative in the Russian view of the Western parochial view of international legality, international law does not have to be argued through rules. Legal claims and arguments can be made by these direct references to historical sense of justice and truth and this mythological sacrifices and uniqueness of the Russian civilization. So in other words, we're dealing here with the Russian version of multipolarity. So therefore, the threat to international law here lies not only in the invasion going unpunished and not even legal rules on the use of force eroding even further, although that is hardly possible. It is also a matter of fracturing international law into these deliberately parochial clusters, justified and covered by the idea of multipolarity, where legal validity and argumentative persuasiveness lack a determinate shared standard. And I was so afraid to run beyond time that I finished 3 minutes earlier. So thank you very much.
That means we are right back on track now. Second, very precise. Alberto, over to you, please. Sure.
So as you can see, changing plans ended not not being the very last presentation. I was planning to be this, and and you are wondering why I've been asking many questions in the last 2 days just to keep myself busy because the last presentation. Anyway, so my topic is a part of a paper I'm working it, and I have to say it's at the very initial stages of the paper. It's a work in progress actually. So it's about the connection between recognition of a government and counterterrorism measures. So I'm asking this a question whether recognizing a new government that its members designated as terrorist by Security Council would be a violation to counterterrorism rules. So a very famous situation now, everybody I think knows about it, the situation in Syria that I'm going to focus on. Of course, it's not only Syria. Actually, even Afghanistan, Taliban is classified as a terrorist group by Security Council. However, Taliban is a government of a state. And then the question whether other states would violate international law if recognize Taliban as a government or the new Syrian government as a government of a state. So we know the situation in Syria, civil war led to emerge of many terrorist groups, including ISIS, Al-Nusra Front, which is later on named itself as Hayat al-Tahrir al-Sham, HTS. HTS then led by Ahmad al-Shara, the current president of Syria. They have managed to overthrow the Assad regime and became the head of the state of Syria. So both Hayat Tahrir al-Sham, HTS, and Ahmad al-Shari or Abu Muhammad al-Julani, both actually are classified as terrorists according to Security Council list of terrorists, and also many other states, including UK, US, European Union, and other states. Of course, we know that in December 2024, they managed to govern the state. Now, I'm good because I had a conversation yesterday with one of the colleagues. He was not sure whether the president is designated as a terrorist group, and this is the list of the Security Council committee, anti-terrorism committee, clearly mentioned the head of the state as one, the STOL actually listed as a terrorist group, or as a terrorist actually here. Then here I have actually a list of different states who have started dealing with the new government at different levels. Saudi Arabia, the first foreign visit by the president, the new president, Qatar, debt repayment, establishing relations, Turkey, diplomatic recognition, United States, conditional engagement, actually, and even they have some levels of meeting with the new administration in Syria. United Kingdom also sanctions relief, and other states also the same level. Here we have kind of diplomatic relations with Syria. We have list of states: Turkey, Qatar, Saudi Arabia, South Korea, Ukraine, Italy, Spain, and Germany. All states have started diplomatic relations with Syria. Okay, so does this mean that these states violated international law by recognizing a government that is formed from people who are designated as terrorists by Security Council? Of course, the issue of classifying rebels as terrorists is very common in non-international armed conflicts. Almost all non-international armed conflicts, you would find central government that would classify rebels as terrorists. But this does not mean that there is an obligation on other states to follow this classification. Internal classification would not create an international obligation on other states to follow or not to follow. So we have many examples: Libya, South Africa, all civil wars in different countries would have the same situation. The problem is recognizing a government that is formed from members who are classified by Security Council as terrorist group. So recognition under international law, of course, refers to the third state's acknowledgement of the new regime or the new administration as the legitimate representative of a state. So when a state recognizes a government, then this kind of acknowledging that this government is representing that state and is a legitimate representative. Then we have two types of recognition, of course. This is very basic rules of international law, the de jure recognition, where a government or a state would produce or issue an official recognition of the government, which is not followed by states. No state now issuing official recognition. This is only applicable to the recognition of states rather than recognition of government. Then we have the de facto recognition. So something can be concluded from the way of dealing with the government. Could include different measures, diplomatic relations, agreements, whatever can be of activities can be used or relied on to conclude that there is a recognition of the new government. Now, the question is there an obligation on states not to recognize the government? Does international law establish an obligation on states for a specific situation to avoid recognition? Normally, recognition is a political act rather than a legal act. So it's a choice, it's a freedom of state. So it's not regulated. We don't have rules of international law say that, okay, when we have such situation, then we would have recognition. And it's not similar to the situation with the statehood or the issue of the statehood. However, although it's a political act, but could have legal implications. So for example, if a state recognizes a government as a legitimate representative of a state, then there could be a treaty between that state and the government. So it could have legal consequences here. However, some scholars actually argue that if the new government emerged from a violation of a jus cogens rule, then there is an obligation on states not to recognize the new government. Of course, the justification for this opinion is the advisory opinion on Kosovo, although it's about the statehood, but the ICJ clearly said if there is of course, said international does not prohibit declarations of independence. However, if it's connected to the violation of a jus cogens rules, such as use of force, then it could be unlawful. The same for the Namibia advisory opinion, 1971. All states has a duty not to recognize South Africa's authority in Namibia. They must refuse to give any support or legitimacy to that illegal situation. So generally, there is no obligation on states not to recognize a government. However, there is a concern that if the government, the establishment of the new government is based on a violation of a jus cogens rule, then there will be concern here. Now, can we consider terrorist acts as a violation of jus cogens rules? So this is a very interesting topic here. We have even the definition of terrorism is not agreed on it. So, but if terrorist groups or terrorist individuals committed one of the serious crimes of international law, which is something under the mandate of the UNITAD, the investigative team of the United Nations, to prove whether ISIS committed one of the serious crimes. Then we would have the question of use cogence here. Anyway, now the next question is, what would be the obligations of states under counterterrorism regime? Counterterrorism regime is established by two main sources, actually. Well, at least generally. We have the sectarial regime, the sectarial conventions. We said that there is no definition of terrorism. However, we have specific conventions that criminalized specific acts and described these acts as terrorist acts. So taking hostages and other conventions, for example, although there is no general definition of terrorism, but these conventions specifically clearly criminalize these acts. Now, the other source, important source, is United Nations Security Council resolutions. So these resolutions impose obligations on states and also establish specific committees to list individuals and groups as terrorist groups or terrorist individuals. Now, if we have a list of people who are classified as terrorists, then there will be obligations on states to prosecute or to extradite, to criminalize, which means that there should be national laws that criminalize terrorist acts, freeze the funds, financial assets, impose travel bans, preventing listed terrorists from entering or translating to their territory, and other kind of support. Perfect. So what I think, actually, this is the conclusion. I think the recognition itself could not be, it's recognition without material support. Some might argue it's not a violation. However, it could be a violation to national law, especially for those laws that criminalize glorification. So if you say that it's okay for a terrorist group to be a government of a state, this is a violation to national law. It's some laws. However, I think generally this will be recognizing a government formatted from or structured, I mean, its members from terrorist group would be a violation to counter-terrorism law, obligation not to provide material support terrorism, obligation not to fund terrorists, obligation to impose travel bans. So I assume now the head of the state, I know we have the immunity issues here, but it comes to the UK, and there is a law in the UK saying that this is a terrorist group and it should be persecuted. Then this will be a violation to international law. I mean, then within national law would be also another issue. I think this is kind of is more than ideas rather than. I was trying to use different justifications here, even within the transnational justice period. But I thought, well, this would not be helpful to find a solution to the problem. And I think this will not be a good practice for international law. Assume now, for example, Boko Haram manages to establish a new government in Nigeria. Can we say this is okay? We have a new practice in international law. Terrorism is terrorism. However, if they succeed in establishing government, then they should be legitimized. So it's a big problem for international law, and I think it could be a violation here. And this is the conclusion of my presentation. Thank you. Sorry.
Okay, after the thrilling moment, now I'm even more ready. So, First of all, thank you everyone for being here. It's the last panel of the day, so really appreciate your presence. I hope not to be too boring. A few words before I start into the topic. So this is a paper that I'm writing as part of a larger project, a larger interdisciplinary project that I'm conducting in Lund, in Sweden, with the Faculty of Medicine. And the project is about scientific disinformation and emerging disruptive biotechnologies. So, cognitive warfare. What is this concept? So, cognitive warfare has emerged recently alongside the other traditional forms of war, the air, land, the seaside, the cyberspace. And it's essentially the use of non-kinetic force, okay, in the international relations to target perceptions, to target the emotions, behaviors, decision-making processes of the adversary and of the civilian population, of course, by producing narratives, by leveraging disinformation, by leveraging propaganda activities, and by producing fear. And a paradigmatic case that one can use to demonstrate how cognitive warfare actually works is represented by the, I would say, the dual use character and potential of biotechnologies. So biotechnologies, in essence, it's scientific advancement in biomedicine, biology, genetics, especially precision medicine, okay? Those are technologies developed, of course, for peaceful and therapeutic purposes, for instance, curing cancer. And for curing cancer, of course, precision medicine, for instance, needs your DNA. So your very personal data. And those technologies, of course, developed for peaceful therapeutic purposes, can also, however, serve strategic and military ends, as we shall see. Now, let me give you some brief examples, and I'm going to go more into details throughout the presentation. You might have been familiar with some of these instances. The odd meeting between Putin and Macron, this long table. Then they didn't even shake hands, and there were allegations that they did so because they didn't want to pass to each other cells of their bodies, meaning genetic evidence or genetic party cells of their bodies. There was, in Russia, in the Duma, there was a whole report falsely claiming that in Ukraine, the US was helping Ukrainians in secret laboratories to develop ethnic bioweapons. And of course, we're all familiar with the pandemic, pathogens, other bacteria, viruses. Who created them? Are they natural? Are they not? How could they be spread? And what could be the consequences? So those are just some examples. Now, actually, cognitive warfare, it is a concept that has emerged in NATO circles. The NATO in 2020, 2021, so we are, in the years of the pandemic, came out with a definition of what they meant by cognitive warfare. So again, tactics to influence and disrupting individual and group cognitions. So we are in the realm of the mind. They do not necessarily carry a kinetic component, as I was saying, and usually these tactics, they rest below the threshold of armed conflict. Very interesting for an international legal perspective. So, of course, in the paper, I'm trying to see what is the framework then of this new type of war. Which framework, which legal framework applies? And for the sake of the presentation, I'm just going to focus on the framework of the use of force in a second, and then more specifically on humanitarian law. Of course, if you have questions on human rights law, I'm very happy to take them at the end. So, as every good public international lawyer knows, we taught this since day one, when we go to public international law class. Well, the two frameworks that regulates warfare is the jus ad bellum, where the key terms are armed attack, the intensity threshold, and when war is declared, then we pass through the rules of humanitarian law, the jus in bello. But the first question is cognitive warfare. Can we really speak of cognitive attacks? Because if we look, for instance, at the jurisprudence of the ICJ, traditional view of international law, well, we know that armed attacks are those of the most grave forms of the use of force. They need to have like grave consequences, right? And even in relation to cyber operation, the Red Cross recently has stated that not all cyber operations will be the starting point, in fact, of an armed conflict. So, and if you look at scholarship, up until, I would say, 2017, propaganda activities, psychological means of warfare, scholarship in international law was not really convinced that those meant, or that those activities could be framed as attacks in the traditional sense. But the first point that I want to make is that, in fact, cognitive warfare might coexist alongside other forms of warfare. Typical example is in Ukraine, you have an armed invasion, so you have guns and tanks, but also other activities, right? And then the other point that I want to make is, since the advent of cyber warfare, here I refer to the Tallinn manual, there is very interesting rule 92, also the notion of attack, the traditional notion of attack has started to change. Here the group of experts say that while the notion of attacks encompasses injury and death caused to individuals, we agree that it's reasonable now to extend this definition to severe mental suffering that are tantamount to injury. So we are seeing a development of the traditional notion of attack. If that is the case, if cognitive warfare coexists, if we agree or we take as good the Tallinn manual, we could also look at cognitive warfare within the framework then of humanitarian law. And here I will invite you to think of the tactics that I was describing. They basically collapse all the cardinal principles of IHL. Distinction, proportionality, precaution. You should always distinguish between military target and civilian targets. But in propaganda activities, disinformation, those kind of activities, they actually do not distinguish between the civilian population and your adversary, the military. Okay? There is also this very interesting concept in IHL of mental harm, a very understudied area of humanitarian law, which I'm particularly interested in. Because humanitarian law, Additional Protocol 1, especially prohibits acts or threats that spread terror among the civilian population, like, for instance, the allegation of spreading a disease, okay? It also prohibits violence to health and mental well-being. But traditionally, again, also humanitarian law has focused mainly on the protection of what is called the life and limb, so the physical body, not the mental aspect. And that's particularly interesting in cognitive warfare. Which leads me to the methods of warfare. And here also some, I would say, not so studied principles of IHL that we find in IHL: ruses of war, perfidy, terror. So, of course, IHL doesn't allow acts that are the sole aim of spreading terror. There is the prohibition of perfidy, and then there is this rule of the ruses of war. Let me give you some examples. A state A, is fabricating or exaggerating the advancement of its genetic research so that the adversary is led to invest time and resources in countering that perceived threat, while actually state A is unfolding military operations somewhere else. That's a typical example of a ruses of war. So that threat is not directed to spread terror among the civilian population, but to strategically mislead your adversary. Now, the lines between ruses of war and terror, however, are porous. Let's take another example. State A is disseminating now information about dangerous pathogens developed in its laboratories, thus inciting fears, okay, of targeted biological attacks against specific populations. Or state is allegedly creating new DNA sequences through synthetic biology. I know that for some, this might sound like science fiction, but when you actually speak to the scientists, like I'm doing and collaborating with them, these things are happening. And we lawyers, we live a little bit in a bubble, I would say. But anyway, the point is, you see the porous line between ruses and terror are not so distinct. The prohibition of perfidy. Again, another example, disinformation campaigns that through which a state is falsely suggesting that a vaccine is being developed, for instance, under the guise of humanitarian aid. We want to save life. Well, actually, the state is using that platform to target specific populations based on their genetic traits. So in that sense, that is an act of perfidy. It's using the trust in the protection afforded by OHCHR to actually generate harmful purposes, for harmful purposes. And reverting back to the ruses, but what if the same state is actually disseminated this information on innovative genetic treatment or a vaccine? This is done, however, with the intent to mislead, again, the adversary in order for your adversary to spend resources on that, to counter that threat, whereas the military operations unfold elsewhere. So that, again, it's not a misuse of humanitarian protection. We are, again, within the realm of ruses of war. So I use these examples to highlight some of the possible scenarios in relation to these principles that we have in humanitarian law. So some final key points. Cognitive warfare, less quantifiable, if you wish, even than cyber warfare, than cyber attacks, okay? It operates through a diverse range of tactics, not all of which, as we've seen, are unlawful. The legality of these strategies depend, in fact, on their specific nature, objectives, and effects on the civilian population. But remember the collapse of the principles, of the key principles of humanitarian law, distinction, proportionality, through these tactics. And also one should consider, perhaps, as the Tallinn manual that I showed you before, Rule 92, a shift now in how we understand attacks, in how we understand the consequences of war or different types of military operations. And perhaps we should shift the focus to the mental and psychological realm of war and its effects, okay, inflicted to the civilian population. So I think I'm very good with the time. Again, I haven't touched upon the application of human rights law in armed conflict in this presentation. I mainly focus on the use of force and humanitarian law, and I'm very happy to take questions, if any. Thank you very much for your attention.